have seen many times in this country, unfortunately, real estate agents and other persons putting up houses for rent and renting property that they do not own. And I find this extremely troubling. Even more troubling because remember, they come by us after things get sour. The tenant who has that responsibility to do due diligence do not feel as if they are entitled to ask a purported landlord and or agent to prove ownership and title. We have a custom in this country, unfortunately, where people enter into tenancy agreements and they take it for granted that the person holding themselves out as the landlord in fact owns the property without seeing any title documentation to evidence the same. That is mistake number one. From step one, if the person purporting to be the landlord does not have the legal authority to be recognized and to act as the owner of the property, then the entire agreement can be made voidable because that party lacks legal capacity. So when you are vetting to check if a landlord owns property, you are checking to see if the landlord party of your agreement has legal capacity. There are 4 ways in which someone can either legally own or be legally recognized as an agent for owning. Are you talking, Mr. Paul? We're just not hearing you.
No, I'm with you. I'm following.
Right. So the first way to own property is to outrightly own it, right? To be in possession of a title document, whether that be under the RPO or under deeds. We have gone through this many times in the previous webinars. You guys ought to know what is ownership of lands now. The second way is by virtue of a lease. If you are an authorized lessee and you have a lease for a lengthy term, let's say 99 years, 999 years, 199 years, and in your leasing agreement, you have the authority or you have the license by your lessor to sublease or to sublet. You have to have that provision. Then you can be viewed as legally having capacity to enter into a tenancy agreement and let somebody else use it. And that's why we usually let and sublet. Yes?
Give us just a practical example of that example there in terms of,
Practical example, most houses in Woodbrook, including my commercial building, is under a lease. So you may have a commercial building to rent and your landlord presents you with a lease from the government, a 30-year lease, a 99-year-old lease. They own it, but they have leased the land and or the property. They are recognized by the bigger lessor, which would be the government in this case, or it could be some big land ownership many years ago. There are many private land holders in Trinidad, and they give persons 99, the estate of this and those larger estates, right, in 𝗏𝗏𝗏𝗏, etc. And they have 999 leases or 99-year leases, but the lease must have the provision to sublease or to sublet, right? And usually in the lease, it will say how. Either it is an absolute license to sublease, or it is a license that is not privileged is the word I'm looking for. It may be
constrained.
No. The word qualified, right? So absolute license mean I could sublease. Qualified license mean there's a condition for the sublease. Usually you will see it's permitted to sublease upon the consent of the lessor. That's very common for HDC properties. HDC properties, both for sale and sublease, it's qualified permission you have. So you will see it there stating that, you have the provision to sublease, but you get a qualified license that you must ask for consent. And the big lessor gives that lessee in writing to sublease to the further sublessee, right? I'm not using people here. It's very clear in my head. Right?
I know, and that's why I said give practical examples. So you have a lease, you are
I want to rent or I want to sell, I must write the proper thing to do, and this doesn't happen a lot. The proper thing to do to make my rental agreement legal and binding is to write to HTC, ask for consent to rent it, get that consent, and then draft my new rental agreement referring to that consent and to that sublease. There are a lot of rental agreements I see the landlord just saying, whereas I am the landlord. By virtue of what? You are supposed to reside upon what authority do you stand? By virtue of deed of conveyance, by virtue of deed of lease, by virtue of, and it's the third way you can own property, virtue of grant of probate, but deed of assent preferably, where you are the beneficial owner. So you would have inherited the property, you probated it, not just that mommy died or daddy died and we all live in here.
Listen, Miss Daniel, the amount of people that come and say, but daddy leave it and mommy leave it for me. And how they leave it.
You must probate, and if we're dealing with, when you finish, get the probate to take the property out of probate and into deeds, you do a deed of assent. A lot of Trinidadians, you would like to just stop by the grant of letter of administration or the grant of probate and all you're done. Stop doing that. Please go and get a deed of assent. All right. That deed is your new title to the property. So your grant is your permission to get it. But your deed is your deed title. Get your deed. Good. So that's the third way somebody could own. And the fourth way, and legally, is by virtue of power of attorney, where someone, where the actual title owner gives you permission to act as the legal attorney or agent, and that has to be represented properly, not just a piece of paper. I say, Mackenzie, no, you have to have a proper power of attorney, and in that document, not just any general power of attorney, there must be clauses that gives that power to lease on my behalf, and to collect rent, and to enter into any agreement on my behalf, and to all of that, collect money, etc., to act as if they are me legally. So those are the four ways, and the four only ways a landlord can actually have authority, right, to rent. Now, a fifth way, this is not very legal, but what can happen if you don't want to pay for a power of attorney, you may have a letter where you appoint X or Y as an agent for you, and your tenant has to agree to recognize that agent. That
person.
Because remember, this is a power of attorney. So it must be an agreement where the tenant say, okay, this is my agent. Now, as a point, a lot of landlords don't understand, you all cannot arbitrarily appoint agents after you sign the agreement. So, for instance, I've seen a lot of times happen. Somebody starts a tenancy agreement, they sign on or they enter into the tenancy agreement or the contract as the landlord. And during the year, they decide to go away and leave their daughter in charge. No.
And daughter to collect the rent.
Daughter collecting rent, daughter don't want to fix, they never fixing the AC, nobody doing any repairs, daughter just collecting the rent. What can happen is that, that daughter could not be paying the rightful landlord completely, and then there's issues, the money never comes. So when you have an appointed agent, right, the tenant and the landlord need to both agree to recognize this agent. And if there's a change, you ought to do an amendment or supplemental agreement to your original agreement, identifying this agent, naming this agent, and saying from this date, the 6th of November, X and Y is now appointed. Right? You should not just arbitrarily institute new agents.
New tenants, yeah. New agents, as you said, yeah, agents, yeah. I mean, that was a lot. That was a lot there. But you know, in a nutshell, Trinidad and Tobago ownership has a look. Ownership has a paper trail. Ownership must have a paper trail. And so, if you are acting as owner or you are acting as an agent of the owner, there must be a paper trail. All right. So
yes.
No paper trail. So let's talk a little bit about the renters. I'm a renter. I want to go into a rental agreement.
Renters. Mr. Paul spoke about paper trail, and I find it very. It's not amusing. It's scary. The amount of people coming to the alarming. The amount of people who identify WhatsApp as a paper trail. You know, we WhatsApp. I have had so many matters in litigation where the entire arrangement was on WhatsApp. Like, I kid you not. You know, we try to facilitate it. I'm not saying that these will not be considered in contract law as non-existent, but don't do that. Please don't do that. You know, we have to jump and skip and do all sorts of things to try to create
formality, Trinidad and Tobago. Formality.